It's an honor for us to host today Professor Leila Sadat. She is the James Carr Professor of International Criminal Law and the Director of the Whitney R Harris World Law Institute at the Washington University in St. Louis. She has written more than 100 pieces, articles, books that foster the discussion in international criminal law. And in 2012, she became the ICC Prosecutor Advisor for Crimes Against Humanity. In 2011, she became the first woman to be awarded the Alexis de Tocqueville Distinguished Fulbright Chair in Paris. And the most important thing, in 2008, she started the process and the discussions about the Treaty on Crimes Against Humanity, and all the discussion about the treaty became today one draft that it has been discussed around the world and the International Law Commission of the UN for a real treaty in the near future, hopefully. Professor Leila Sadat, as I said, it's an honor. The floor is yours.
Oh, yes, I'm shorter. Oh, perfect. Thank you so much. Thank you, ladies and gentlemen, distinguished guests, dear colleagues, and friends. I bring you greetings from the sister city of St. Louis, Missouri, and in particular, I bring you greetings from the Harris World Law Institute, named, of course, after Whitney R Harris, who stood in this courtroom 70 some odd years ago today and assisted Justice Robert H. Jackson and the Nuremberg trials. It's an honor to be here. I thank very much the International Nuremberg Principles Academy for the pleasure and the privilege of being here on this auspicious occasion and in such distinguished company. There may be storm clouds around us, which have been alluded to by the prior speakers, but the light is absolutely very bright in here. Indeed, as the conference note for this conference suggests, the Nuremberg Academy and the Nuremberg Principles emanate a beacon of light towards which we hopefully can steer the ship of accountability for international crimes towards peace and justice and calmer waters. I'm looking forward to our discussions over the next 2 days, and I know that under the leadership of the Academy and the chairs, we will make a great deal of progress. I'm very, very honored and grateful to be here. On November 21st, 1945, in this very courtroom, my countryman, Justice Robert H. Jackson of the United States, pleaded the Allied case to the International Military Tribunal charged with trying the Nazi leaders. He knew that the case was novel and that the leadership of the Nazi regime would argue, as the Americans had argued after World War I, that heads of state and other government officials answer only to their own people, not to the international community as a whole. Although Article 7 of the Nuremberg Charter provided otherwise, that official position of the defendants could not be considered as freeing them from responsibility, Jackson understood intuitively that this was a new idea. He anticipated pushback from the accused and met their anticipated rejoinder head-on in one of the most iconic elements of his opening address, stating, and I quote, "The common sense of mankind demands that law shall not stop with the punishment of petty crimes by little people, but must also reach men who possess themselves of great power and make deliberate and concerted use of it to set in motion evils which leave no home in the world untouched." Jackson's famous assertion that even the highest-ranking leaders of a state are subject to the rule of law is one of the most powerful contributions of the charter and judgment of the International Military Tribunal to the world. It was a clear rebuke to the failure to hold Kaiser Wilhelm responsible following the First World War, a failure that the great powers had essentially countenanced, although nominally demanding his extradition. In 1950, during its second session, the new International Law Commission of the United Nations codified Jackson's argument and the decision of the tribunal as Nuremberg Principle 3, finding that the fact that a person who committed an act which constitutes a crime under international law acted as head of state or responsible government official does not relieve him from responsibility under international law. This provision also found its way into Article 4 of the Genocide Convention of 1948, and later when international criminal justice reawakened after the end of the Cold War, it found its way into the statutes of the Yugoslavia and the Rwanda Tribunal, and subsequently the Special Court for Sierra Leone and the Extraordinary Chambers in the courts of Cambodia. It also found its way into Article 7 of the International Law Commission's 1996 Draft Code of Crimes, and the Commission suggested that this draft code could either become on its own a new international treaty or incorporated into the statute of a future international criminal court. The commentary to the draft code of 1996 says not just that Article 7 allowed individuals not to plead their responsibility as a matter of substance, but in addition, and this is very important, said, the absence of any procedural immunity with respect to prosecution or punishment in appropriate judicial proceedings is an essential corollary to the absence of any substantive immunity or defense. And the commentary continues further, it would be paradoxical to prevent an individual from invoking official position to avoid responsibility for a crime, only to permit him to invoke the same consideration to avoid the consequences of that responsibility. The Commission did not define in 1996 which judicial proceedings would be considered appropriate, but the clear implication of the draft code is that they included proceedings before international courts, such as a future international criminal court, and before states exercising universal jurisdiction. Today, we are seeing, however, at least some members of the Commission retreating from this position in its work on immunities, and even some flickering of ambivalence in its work on crimes against humanity. Yet accountability for international crimes, and even for ordinary crimes, is critically important today, even if it's a harder sell than it was just 2 decades ago. During the remainder of my remarks, I will discuss this issue first in light of the important case law of the International Criminal Court in the Appeals Chamber decision on the al-Bashir case, and then briefly take up the question of accountability beyond the ICC, which is, of course, the subject of our conference today. At the International Criminal Court, the Rome Statute in Article 27 has 3 essential provisions. The first part of Article 27 of the statute says that the statute applies equally to all persons without distinction based on official capacity. The next provision of Article 27 is a reprise of Nuremberg Principle 3, saying that official capacity is not a defense, essentially, to an international crime. And the third provision of Article 27, 27.2, says immunities or special procedural rules which might attach to official capacity shall not bar the court from exercising its jurisdiction. Article 27 was referred to by former High Commissioner for Human Rights, Zeid Ra'ad al-Hussein, as, quote, the most profound article to ever be written into a multilateral treaty. And yet, it was during the ICC negotiations, according to Per Saland and others who were there, essentially uncontested throughout the discussions and relatively easy to incorporate into the new treaty. It reprised almost verbatim the work of the International Law Commission and the International Criminal Tribunals for the former Yugoslavia, and Rwanda had referred to it as a provision of customary international law, as did the Special Court for Sierra Leone in its decision in the Charles Taylor case. Today, however, the meaning of Article 27 is hotly disputed. Individuals on the receiving end of the court's investigations, subpoenas, or arrest warrants have protested its application to them and have successfully had their governments, over which they often preside, take up their case. This has led several states parties to the Rome Statute to assert that they are unable and unwilling to surrender individuals who might have immunity under international law to the court without the consent of their state of nationality. The most recent example was the Hashemite Kingdom of Jordan, which pleaded fundamental rules and principles of international law that required it to refuse to execute an arrest warrant of the court for President al-Bashir of Sudan on the basis of his alleged immunity when Bashir was invited by the kingdom to attend a meeting of the Arab League in Jordan. Although the kingdom's argument was cast procedurally in terms of Article 98.1's interaction with Article 27, the brief for the kingdom asserts essentially that heads of state remain immune under international law so long as they remain in office, whether the jurisdiction before which they are sought is a national or international court, which in my view turns nearly 75 years of customary international law on its head. The 6 pretrial chambers of the court that examined the question of al-Bashir's immunity under the Rome Statute prior to Jordan's appeal concluded that states parties to the Rome Statute had an obligation to arrest President al-Bashir and other heads of state, whether from state or non-states parties, but were admittedly inconsistent in their reasoning. Early decisions relied upon the Rome Consensus and the Nuremberg lineage of the statute to find it completely obvious that he had no immunity before an international court. The constant drumbeat of my own country, the United States, as well as the African Union's opposition, among others, and an avalanche of scholarly work protesting the application of the statute to heads of state and to non-states parties had the effect of pushing the court's chambers to reconsider their views. The decision of the appeals case then, last year, in the Jordan case, represented an opportunity to consider this idea much more fully. In the al-Bashir case, and I spend some time on this because it's important to our discussion today, in the al-Bashir case, Jordan argued that Article 98 essentially negated the application of Article 27. It argued that Article 27, too, that is the procedural immunity part, did not remove his immunity under conventional and customary international law, that the Convention on Privileges and Immunities of the League of Arab States immunized him from arrest and surrender, that the Rome Statute cannot impose obligations on or deny rights to states not parties to the statute, which is a reprise of the United States argument of 1998, and that Security Council Resolution 1593 did not in any way affect Jordan's obligations under international law to accord full immunity to President al-Bashir. Jordan's position then, obviously, if it had been fully accepted by the court, would have essentially have meant that the ICC could not ever exercise jurisdiction over presidents of other states without a waiver of their state of nationality. Jordan's answer to the potential impunity presented by its legal position paralleled the response of the ICJ in the Eurodia case, that immunity is not tantamount to impunity because immunity ratione personae, enjoyed by a head of state from foreign criminal jurisdiction, ends when he ceases to hold office. Yet, had al-Bashir not been removed from power by his own military, that wait could have been quite long indeed. As a close observer myself of the Rome negotiations in 1998, I find Jordan's argument unpersuasive, although I have great respect for its advocates. The travaux préparatoires of the Rome Statute indicate that Article 98 was inserted late in the negotiations of a way of addressing situations where evidence might be found in, for example, the diplomatic premises of a third state on the territory of a state party. According to the negotiating history, it was never intended to undermine Article 27. Indeed, Sir Arthur Watts observed in his Hague Academy lecture, which was in 1994, a few years prior to the Rome Statute, that, quote, "It can no longer be doubted that as a matter of general customary international law, heads of state can be called to account personally if there is sufficient evidence that they have authorized or perpetrated serious international crimes." This rule is also found not just in the Travaux prior to the Rome Statute, but even as late as 2015 in the Kosovo Specialist Chambers Statute, we still see an exact redaction of Nuremberg Principle 3, showing its demonstrable understanding as customary international law. In May 2019, the ICC Appeals Chamber, as is probably well known to this gathering, rejected Jordan's appeal, finding that Jordan should have arrested the president of Sudan, but that Jordan would not be referred to the ICC Assembly of States Parties or to the Security Council for non-compliance. The decision allowed Jordan then to save face, essentially, but upheld the integrity of the Rome Statute. The chamber held, and I quote, "There is neither state practice nor opinio juris that would support the existence of head of state immunity under customary international law vis-a-vis an international court. To the contrary," it said, "such immunity has never been recognized in international law as a bar to the jurisdiction of an international court." The appeals chamber noted that the burden of proving this rule of customary international law would be on the party arguing for its existence, which of course is consistent with the Lotus Principle articulated by the Permanent Court of International Justice in 1927. It observed that the absence of a rule of custom recognizing head of state immunity before international courts is explained by the different character of an international court when compared with the domestic jurisdiction, rejecting Jordan's characterization of the ICC in its pleadings as a, quote, "foreign court." The appeals chamber also found that although domestic jurisdictions constitute an expression of a state's sovereign power, which is necessarily limited by the sovereign power of other states, international courts conversely act on behalf of the international community as a whole. It recognized in this way a difference between what I call universal international jurisdiction and interstate universal jurisdiction, meaning that it differentiated between the application of international criminal law by international and national courts. Thus, the appeals chamber rejected the arguments of the African Union and other amici who took the position that the immunity ratione personae of heads of state is absolute, even in the case of genocide, on the basis that any arrest or prosecution will inevitably interfere with their functions on behalf of the state, so long as they remain in office. The blogosphere erupted after the appeals chamber's ruling. Dov Jacob argued that it was, quote, "the worst possible solution." Ben Batros wrote on Just Security that the outcome was, quote, "correct, but the means was unusual and raising eyebrows." Dapo Akande wrote on Ijol Talk that the decision was, quote, "stunning and deeply misguided," and added for good measure that it was, quote, "very dangerous and unwise." Other voices have now joined the conversation defending the decision, including, in full disclosure, my own, as well as that of Professor Klaus Kress, one of the amici in the case. But overall, a wave of criticism was directed at the ICC in the wake of this decision. As I wrote recently on Just Security, I take a different view. I think the decision was unsurprising, correct, and consistent with the court's judicial mandate. And I think that the explosion of litigation and scholarly writings around the interaction between the two provisions, 2798, sparked by the travels of former Sudanese President al-Bashir, represent an effort to change customary international law that was embedded in the Rome Statute in 1998 and represent a frontal challenge to the accountability principles that the Rome Statute contains. Because the appeals chamber's judgment was unanimous, it seems unlikely that this issue will return to the court and continue to be litigated there, although there will undoubtedly continue to be some conversation about it at the Assembly of States Parties and perhaps before the ICJ, given the campaign to bring the issue to the International Court of Justice for decision. Yet, it's important, I think, for us to take a hard look at this decision, even if the ICC law is settled. The ICC judgment may have settled the law at the ICJ, and it may have essentially established the right of the court to issue arrest warrants demanding the surrender of high-ranking officials, but it's still under question in many quarters. And of course, as the center of the international justice system, right, what happens at the International Criminal Court affects the entire system, particularly on questions of customary international law. And for this reason, I'd like to take just a few moments of my time this morning to talk about some additional arguments advanced either implicitly or explicitly by Jordan and its advocates during the hearing on the case in 2018. The first argument that I've heard is that through the persistence of the arguments advanced by the United States and members of the African Union, customary international law relating to immunities, that is Nuremberg Principle number 3, has changed. If state practice is the key to determining the content of a rule of custom, the argument goes, the protestation of a significant number of states have the ability to change a rule of custom once created. Thus, even if there was a rule, goes the argument, enshrined in Article 27, rendering heads of state subject to the jurisdiction of the ICC and its cooperation regime, maybe that rule no longer exists. I can make several responses. First, the number of states actually protesting is relatively small, although some, like the United States, are powerful and others have been vociferous. Even within the African Union's membership, a significant number of states have not supported the AU's position on al-Bashir's immunity. Article 46A bis of the Malabo Protocol, adopted by the AU, includes a provision on immunities stating that, quote, no charges shall be commenced or continued before the court against any serving AU head of state or government, or anybody acting or entitled to act in such capacity, or other senior state officials based on their function during their tenure in office. The protocol has, as of today, 15 signatures and no ratifications. The South African and Kenyan courts hearing the cases on al-Bashir's immunity found there is no immunity for heads of state accused of Rome Statute crimes as a matter of customary international law. So the evidence of a customary shift, I think, is very weak. Second, the norm is a jus cogens norm that by its terms is non-derogable. The appeals chamber explored in its September 10, 2018 hearing what the consequences of jus cogens status might mean for its opinion, and it's worth noting, again, that national courts that have looked at it, like Kenya's Court of Appeals, concluded al-Bashir did not have immunity because of the jus cogens nature of the crime alleged. As the ICTY found many years ago in the Forenza case, the jus cogens status of a norm is not only a matter of substantive international law, but entails various procedural consequences. The ICC statute has to be read in light of relevant customary international law, including the 25 years of jurisprudence emanating from the ad hoc international tribunals to avoid fragmentation, to encourage and enhance the legitimacy of international criminal law, and of course, as commanded by the ICC statute itself in Article 21(1)b. Third, it's not clear to me that the relevant actors for asserting the content of a new rule should be heads of state, given that they are inherently self-interested in the content of the rule. This raises a profound question on the formation of customary international law, but it's worth noting that African civil society and 2 African courts asserted the continued validity of the current rule by insisting upon its currency, and in the cases of Kenya and South Africa, finding their own governments in violation of the Rome Statute treaty obligations for failure to cooperate with the ICC. Customary international law arguably rests upon the general patterns of expectation, opinio juris, of humankind, not merely that of their representatives. Fourth, and on a related note, as we've seen with the United States and its somewhat tortured relationship with the International Criminal Court, views change from administration to administration, suggesting that opposition to the rule in Article 27 is not firm, but varies with the political preferences of particular leaders. To the extent that the ICJ was willing to admit of temporal immunities to the prosecution of heads of state for core crimes, it was because, in its view, heads of state could be pursued upon leaving office. However, heads of state often have astonishingly long tenures, amounting essentially to lifetime appointments. This is true in Africa, but it's true elsewhere as well. President Xi Jinping of China recently is given a life tenure, and my president, US President Donald Trump, chimed in after that happened that, quote, "President for life, I think it's great. Maybe we'll have to give it a shot someday." Fortunately, the 22nd Amendment of the United States Constitution limits him to 2 terms. No comment. Finally, one last argument could be, I need a glass of water, that a regional custom for Africa has been created, opting out of the regime applicable to the rest of the world in terms of immunity and relevance of official position. Such a regime, I think, would probably be undesirable as a matter of policy for the reasons we all know well, and it's not been firmly established in light of the Malabo Protocol's complete non-ratification. Finally, is it even possible to establish such an opt-out regime, giving the status of the norm as jus cogens? But now this brings me to the central question of this conference, which is accountability beyond the International Criminal Court. The fundamental point of equality before the law is currently under stress in many countries in the world, including my own. And the question of immunities has come back to the International Law Commission, as well as it's been raised in the drafting of the new convention before the ILC, on crimes against humanity. In July 2017, the Commission provisionally adopted Draft Article 7 on exceptions to immunity ratione materiae of state officials from foreign criminal jurisdiction by a contentious and recorded vote of 21 in favor, 8 against, and 1 abstention. The 21 in favor found that immunity did not apply to 6 international crimes: genocide, crimes against humanity, war crimes, apartheid, torture, and enforced disappearance. One could quibble about the list of crimes, but of particular concern to me isn't so much what was included, but the partial retreat, it seems, from the Commission's Code of 1996. The proponents of immunity, who objected to Draft Article 7 of the Commission, argued that there was insufficient state practice to support Draft Article 7. The fact that the Commission had a court-recorded vote and the report became so controversial suggests to me that the pushback to Nuremberg Principle 3's implementation has become deeply entrenched, and not just with respect to the International Criminal Court. With respect to the work of the Commission on Crimes Against Humanity, there is a reprise of Article 7 of the 1996 Draft Code of Crimes, and the Commission has included Draft Article 6.5 of the new Articles on Crimes Against Humanity, a proviso stating that the fact that an offense referred to in the draft was committed by a person holding an official position is not a ground for excluding criminal responsibility. At the same time, the discussions that I observed in the Commission suggested that they were not seeing this, and the Special Rapporteur has made that clear, as a reprise of Article 27 of the Rome Statute, but merely as a nod to the absence of immunity ratione materiae. For this reason, it may be that the Commission's 27 draft is much weaker than its 1996 thinking. Nonetheless, one has to say, and thank you so much for recognizing it, that the elaboration of a complete draft convention on crimes against humanity, which will be discussed in the next 2 weeks in the 6th Committee of the United Nations, is an enormous step forward and a tribute to the enduring importance of the Nuremberg Principles. Yet it's not so clear to me what states will do with the Commission's important work. And here, just petit parenthèse, we have to really work hard to see that this draft goes forward. Turning back then to the question of immunities and Nuremberg Principle 3, we're seeing, I think, in the work of the Commission, in the advocacy of states in the al-Bashir case, that the pressure exerted on the ICC to water down the application of Article 27 is having a ripple effect in other international fora and even in national systems. Domestically, in many countries, including my own, claims from the executive branch that the courts have no power to subject them or their actions to judicial process have been increasing in number and force. Although immunities that protect government officials from personal liability for their official actions have long been seen as positive, blanket immunities endowing particular individuals absolute immunity during their tenure seem more akin to notions of sovereignty based upon the person of the king or queen than are consistent with democratic or republican principles of governance. The president of my country has been ordered on several occasions in the historic past by the U.S. Supreme Court to comply with the law in case of investigations by Congress as well as civil litigation. Whether this will continue in my own country in the face of not only an effort to pack the federal courts, but the 45th president's insistence upon absolute and unqualified immunity in all cases is unclear. The court battles fought in my country and around the world seeking to hold high government officials responsible for ordinary crimes committed even during their tenure in office, such as obstruction of justice or interference with election, are hard-won gains seeking to enforce the idea of equality before the law. While recognizing the need for flexibility in application, these cases demonstrate a desire to insist upon accountability as an antidote to corruption and dictatorship. And an insistence upon accountability for the commission of jus cogens crimes by national systems should be a principle that is in fact strengthened and not weakened by the establishment of the International Court. Many countries had to amend their constitutions to remove presidential and other immunities in order to ratify the Rome Statute, and that includes many countries on the European continent, particularly France, with which I'm most familiar. It would be a high price indeed to pay if the establishment of the world's first permanent criminal court resulted in enhanced immunity for heads of state and other government officials at the international and national level, rather than enhanced accountability. In a world where civilians and civilian objects, like hospitals and schools, are increasingly becoming the target of great power and small power bombing campaigns, torture has been carried out or abetted by military personnel even of democracies, and acts of aggression have become increasingly frequent as evidenced by recent events, the Nuremberg Principles are needed now more than ever, particularly Nuremberg Principle 3. Whether before an international court or a national system, claims that jus cogens crimes can be committed with impunity because of an individual's position are not consistent with either a desire to prevent the crimes or to bring those who perpetrated them to justice in any kind of a timely fashion. Although I believe that those, like the ICJ in the Eurodia case or the ICC appeals chamber in the al-Bashir case, were correct to distinguish the horizontal application of international criminal law between sovereign states and cases of its vertical application by international courts. But even there, one has to ask the question, are the commission of genocide, aggression, war crimes, or crimes against humanity really acts of state? And I think that is the question that lingered in the air in the 1990s. It's been sort of answered in the negative recently, but I believe that that question still has to be addressed more fully, particularly when we think of accountability outside the International Criminal Court. Now, it may seem quixotic to insist upon accountability in the face of so much concerted pushback, but it's important to do so if the gains of the past 75 years are not to be lost. I don't think, however, that the pushback is surprising, nor is the contour of the debate. As the famous political economist Albert Hirschman has written, the rhetoric of conservative reaction to progressive ideas that we are witnessing in response to ICC interventions, for example, or that we saw with respect to cases involving universal jurisdiction, is a rhetoric premised on three core arguments. First, perversity, futility, and jeopardy. Perversity, that the ICC intervention or the universal jurisdiction situation is making matters worse. We've seen this argument made by diplomats who objected to the arrest warrants against Joseph Kony and scholars like Dan Kramaric who've argued that if only the ICC didn't exist, maybe Assad of Syria would somehow have gone into a happy exile and stopped his slaughter of Syrian civilians. There's also the tendency to argue that commitment to the International Criminal Court and the values of the statute is a fool's mission because things are unlikely to ever change. This argument of futility, plus ça change, plus c'est la même chose, right, is commonly heard as a plea to stick to the status quo, combined with pontification about the dark nature of human beings. And finally, the most serious response is the argument that the progressive development of the law will actually jeopardize or harm existing legal structures, undo positive rules, and erase existing gains. This, in fact, was the crux of the anti-ICC argument in 1926 when the International Law Association tried to draft a statute which postulated that the establishment of a court could prevent diplomats from shaking hands and moving beyond past atrocities, because lawyers would start a second war of recrimination. Objections to holding government leaders accountable in national systems are of the same kind, that to do so risks destabilizing and collapsing the entire system. To this rhetoric of reaction, as he calls it, Hirschman responds that, to paraphrase the Reverend Martin Luther King Jr., the arc of history is long, that it does indeed bend towards justice, and that time and hard work is what's needed to make progress on the difficult problems of the world. Whether or not this is a correct assertion is difficult to ascertain, but if I had to choose one view of the other, I would choose the optimistic one, because we've already seen the pain of what the view of 1919 wrought in the world. In any event, there's very little empirical evidence suggesting increased accountability leads to increased violence. So I now turn to some final thoughts, especially in light of the fact that coffee is coming soon. In today's world, unlike the world of 1998, heads of state are increasingly assertive about their prerogatives and their powers. Now, if those heads of state and the leaders of many countries want a provision like the Malibu Protocol to become international law, they could, of course, propose amending the Rome Statute at the next review conference to include new texts that will explicitly exempt their heads of state and presumably a list of other defined persons they believe to be immune from the court's reach. Setting aside concerns about the legality of such a provision with respect to Hughes Kogan's crimes, if this is the desired outcome, which was argued in the al-Bashir case, it should be made explicit by states. They should have to bear the political cost of taking this motion forward and not try to implement it through the judicial back door, or even through a collateral attack on the al-Bashir judgment through the International Court of Justice. And it's worth noting that this new model has been tried before. It's the impunity paradigm of 1919. It's unclear to me why states believe it will work better this time than it did the last time around. It is true that removing heads of state immunity and other high government official immunity before international courts and national jurisdictions feels different when it's applied broadly and prospectively rather than in targeted fashion to the losers of the last war. And African states are right to be wary, given the world's history of colonial oppression towards them. But Nuremberg Principle 3, as a rule of law, was a radical, important, and revolutionary advance. Abiding by it today requires government officials to put the interests of the international community and the victims of atrocity crimes above their own self-interest, which is hard to do. But doing what is right, even when it's hard, is the hallmark of statesmanship. In a 1952 speech commemorating United Nations Day, U.S. Democratic presidential hopeful and former UN ambassador Adlai Stevenson wrote of the United Nations, and I quote, "The early years of the United Nations have been difficult ones, but what did we expect? That peace would drift down from the skies like soft snow, that there would be no ordeal, no anguish, no testing in this greatest of all human endeavors. Any great institution or idea must suffer its pains of birth and growth. We will not lose faith in the United Nations. We see it as a living thing and will work and pray for its full growth and development. We want it to become what it was intended to be, a world society of nations under law, not merely law backed by force, but law backed by justice and popular consent. We believe that the answer to world war can only be world law." These words of Adlai Stevenson could be said of the International Criminal Court and the Nuremberg Principles today. The ICC is having its struggles. National systems are struggling too. But Nuremberg Principle 3, the principle of equality and accountability before the law, is a timeless statement of what law should be for law to work, and it costs the lives of millions to achieve. Although a balance must be sought between the legitimate needs of a state's leaders to interact freely with the world in representing their nations and the need to prevent, investigate, and prosecute international crimes, Nuremberg Principle 3 should be at the center of that discussion. Dame Rosalind Higgins reminds us in Problems and Process that international law is not just a set of rules, it is a complex and integrated legal system, some rules of which have primary or quasi-constitutional status. Nuremberg Principle 3 is one such provision. Navigating the difficult questions of the world's complexity requires us to set course by the stars, not by the light of the passing ships. The Nuremberg Principles emerged from one of the darkest periods of human history and remain today as a beacon, steering us home even when the water is rough and the skies are dark. Following them, even when it's hard to do so, remains, as Justice Jackson admonished us in this very courtroom 70 years ago, the greatest tribute that power can ever pay to reason. Dear friends, ladies and gentlemen, thank you so very much.